The Afghan inquiry has set a deadline of next week by when the Veterans Minister, Johnny Mercer, must reveal the names of the SAS whistleblowers who gave him sensitive information in confidence about the alleged murders of innocent people in Afghanistan. But today, The Times reported that sources close to Mercer have said he would be willing to go to prison before disclosing the names of the whistleblowers. In February, Mr. Mercer, a former officer, told the inquiry that Special Forces soldiers had raised concerns with him about alleged executions of innocent civilians in Afghanistan, as well as other concerning information regarding the mistreatment of Afghans. The inquiry chairman, the very distinguished Lord Justice Haddon Cave, ordered Mercer to reveal their names, promising to protect their anonymity. But Mercer refused. Mercer was then told he had a deadline of the 5th of April or face a prison sentence. But the deadline has now been extended until next week. But this is a troubling case about the balance between the judiciary and Parliament. Our Constitution works on a balance between the two. As a rule, MPs are answerable in civil matters to their constituents, not to the courts, and historically are exempt from civil but not criminal arrest. And much in the same way that when a defendant confides in his lawyer, or when a source confides in a journalist, a whistleblower has the reasonable expectation of anonymity when giving sensitive information to a member of Parliament. It is extremely rare that a journalist or a lawyer would have to hand over the names of sources of sensitive information. And I think the same should apply here. If these names were to be given to the inquiry, it would discourage other whistleblowers from coming forward. But on a more fundamental level, Parliament is the highest authority in the land, higher than the courts, because it's representative of the people. A move like this would discourage anyone from giving sensitive or possibly vital information to a member of Parliament who may be able to do his job better with such knowledge. As ever, let me know your thoughts, mailmog@gbnews.com. And I'm joined now by a friend of the programme, legal consultant in human rights, Fadi Farhat. Fadi, thank you very much for coming in. This is a very interesting issue because the allegations are tremendously serious, and it is important that we find out if people were murdered by British armed forces, and that's what the inquiry is doing. But is it right that the judge should then appear to have this power to extract information from someone?
Well, when this matter first broke out, Jacob, back in March, and I remember referring to the Inquiries Act 2005, and I had a look at Section 21, which provides the chairman powers to make a notice under that section. And broadly, there are three broad provisions. One is to give evidence, the power to compel to give evidence or to provide evidence in written form. And two is to provide any documents in one's custody, or three, to provide or produce anything in one's custody. This isn't a document. The names of the SAS officers are information. Mm-hmm. So it's not a document or a thing in one's custody. And so it can only be, the power can only apply to the power to give evidence or to produce evidence. And in my view, that may not, arguably, may not extend to compel to give evidence and dictate the content of that evidence. John Mercer has already given his evidence as to what was said to him, and it's questionable whether the power then extends to compel him to produce evidence and dictate the content of that evidence, which is what he's being told to do by producing the names.
I see. So there's at least an argument that though you can compel somebody to give evidence, you can't compel the extent of that evidence. Indeed. As long as what they say is true in the evidence that they give.
That seems to be a plausible interpretation on the wording of Section 21, and Parliament may have intended that to at least provide evidence, but not to dictate or the extent of that evidence.
And in what I hope is the unlikely eventuality that Johnny Mercer were to be sent to prison, how would that function? Would he go for trial before jury, or would it be the unilateral action of a judge?
The Act says that under Section 35 that the chairman could institute proceedings or start proceedings, and it's and one's liable for summary conviction up to 51 weeks imprisonment. So that's that. But inbuilt in Section 35 is whether you have a reasonable excuse defence.
Yes.
So even in the event of a breach, one could still present the reasonable excuse defense. And John Mercer has already pointed to the fact that his reasonable excuse is that there are public interest considerations in not divulging the names, as well as the officers being vulnerable or the officers being susceptible to reprisals or their family members. So there are wider issues that he could point to in providing that reasonable excuse defense.
And there are other people who have an interest in this, aren't there? I mentioned journalists and lawyers because, as a general but not absolute principle, journalists can protect their sources and lawyers do not have to sneak on their clients.
Yes.
And this is fundamental to a democratic society with free speech and the rule of law.
Indeed, indeed. And to public inquiries, which is what this is, because John Mercer's provided his evidence and we've obtained valuable information from that. If officers were to if the president were to be said that you're going to be named, or there's a risk of that, in future officers may not come forward, and the evidence that John Mercer has provided to the inquiry would not be given in future.
And it changes.
Because he wouldn't have the information.
He wouldn't have the information.
Yes.
You wouldn't say that you'd got the information and you wouldn't get it because people wouldn't come to you.
Indeed.
And this, for members of Parliament, is, I think, a real problem to how our constitution works, because people come to their MP week in, week out, with an expectation that their conversation will be confidential and that it won't be passed on and that it informs the Member of Parliament, and they may then want the MP to do something, but that it won't be revealed to somebody else.
Yes, exactly. But ultimately, the answer or solution to this problem will be from Parliament, because Parliament can clarify the powers under Section 21, because that's these powers are not inherent. They stem from the Inquiries Act 2005, and it's open to Parliament to amend that and clarify the provisions.
And that would be better than getting into the very complex constitutional grounds of whether you can imprison a Member of Parliament in these circumstances, because it's always very straightforward that if a Member of Parliament breaks the criminal law, murders somebody or any of that sort of thing, there is no exemption for MPs, and there almost never has been in our history. But MPs have always been protected against civil actions to stop them being arrested in civil cases.
Yes.
And this is in something of a grey area, isn't it, between
Indeed,
the two?
We are entering this dark, labyrinthine corner of our constitution. And I think the solution would be for Parliament to clarify the Inquiries Act rather than necessarily enter into that area. But it's a very interesting area as it is, yes.
Well,
ultimately will need to be resolved one way or another.
I find these corners of the Constitution absolutely fascinating, but I may be in a minority in that. How much discretion does the judge have in terms of the inquiry? Could he simply decide that it is not in the public interest to proceed and drop the request for evidence? Or having gone this far, is he in some sense obliged to carry on?
No. So Section 35 appears to provide that discretion. So even in the event of a breach, the discretion is that the chairman has a broad discretion whether to institute proceedings for what is quasi-contempt almost.
And I suppose the case for where he's gone so far is that actually finding out if things went wrong in Afghanistan in the way that's been suggested is really very important, because as a nation we've always prided ourselves for generations on proper behaviour in war. That's not to say that war isn't horrible and cruel and doesn't kill people, but that we have abided by the rules of war, and that in trying to find out or allegation that hasn't happened, that is a serious matter that needs proper investigation.
Indeed, yes, that is a serious matter that needs investigation. On the other hand, perhaps revealing the names would then enable the inquiry, the public inquiry, to call the officers with safeguards, and therefore use that as a platform to extract more information from which we can draw lessons. But the other side of the argument is that John Mercer's probably provided that already.
Having as a third party.
Yes, and all you're going to have is then duplication, which is unnecessary.